Understanding keep and pay, a bankruptcy exemption. In the challenging landscape of personal finance, bankruptcy can offer a fresh start for individuals struggling with insurmountable debt. However, the fear of losing essential assets during bankruptcy often deters individuals from filing. Enter the concept of keep and pay, a legal strategy that can aid debtors in preserving their significant assets even as they declare bankruptcy. This article delves into the nuances of the keep and pay option, its workings, rules, and practical implications. What is keep and pay? Keep and pay refers to a specialized bankruptcy exemption strategy that allows individuals to retain certain assets that would typically be subject to liquidation during bankruptcy proceedings. By agreeing to a repayment plan with creditors for the value of the retained asset, debtors can maintain possession of critical personal property, such as a home or vehicle. Key takeaways. Asset retention. Keep and pay is a strategy enabling borrowers to retain non-exempt assets after declaring bankruptcy. Repayment agreement. The debtor must agree to repay the creditor an amount equivalent to the value of the retained asset. State variability. Rules governing keep and pay arrangements can vary significantly from state to state. How keep and pay works. During bankruptcy proceedings, particularly under Chapter 7, debtors are often asked about their intentions regarding their assets. They can opt to surrender non-exempt property, redeem it by paying its value, or propose a keep and pay agreement. When filing for bankruptcy, an individual must submit a detailed plan indicating how they plan to manage their payments on the retained asset. This plan usually requires court approval, and the creditor must also approve the terms. Creditors generally favor keep and pay plans if they believe that it increases their chances of full repayment. For instance, in cases where liquidating an asset such as a house involves lengthy court processes and additional costs, creditors may prefer keep and pay agreements as it streamlines the repayment process and enhances recovery potential. Example scenario. Consider an individual who files for Chapter 7 bankruptcy and has a home valued at $250,000 but an outstanding mortgage of $200,000. If the homeowner opts for a keep and pay arrangement, they must demonstrate their ability to manage the monthly payments through a detailed financial plan. If the court and creditor approve the plan, the homeowner retains their property while committing to repayments. Keep and pay and state regulations. The rules surrounding keep and pay differ across states. Most states impose their own unique set of bankruptcy exemptions, dictating what amounts can be retained during bankruptcy proceedings. Some, like California, offer dual exemption frameworks, allowing filers to choose whether to follow state or federal guidelines. For example, if the state exemption threshold permits retention of up to $175,000 in equity, a homeowner with a property valued at $160,000 and a mortgage of $140,000 would be safe to keep their home. However, if their property's value exceeds this threshold, the court may appoint a trustee to liquidate it. Before deciding to file for bankruptcy, individuals should consult with a legal professional to understand their rights, state-specific exemption thresholds, and the feasibility of a keep and pay strategy. The significance of keep and pay. Keep and pay can significantly impact a bankruptcy filer's financial future. An effective keep and pay agreement can preserve assets, protect essential properties like homes and cars, which might be crucial for daily living or commuting. Reduce creditors' hassles, simplify the repayment process for creditors, who may otherwise have to navigate lengthy liquidation procedures. Provide stability, allow debtors to maintain a sense of normalcy amid financial turmoil. That said, keep and pay agreements are not universally applicable to all significant assets. Creditors are more inclined to accept keep and pay proposals if they see a genuine effort on the part of the debtor to alter their financial habits and demonstrate favorable repayment prospects. Restrictions and limitations. While keep and pay may offer financial relief, debtors should remain aware of its limitations. 1. Not all assets qualify. Keep and pay may not be offered for all large assets, many may still face liquidation. 2. State-specific guidelines, regulations governing keep and pay vary, making it important for filers to understand their state's provisions thoroughly. 3. Debts post-bankruptcy. Not all debts are dischargeable through bankruptcy, including certain taxes, student loans, and child support obligations. Conclusion. Declaring bankruptcy doesn't necessarily translate to losing valuable assets. The keep and pay strategy presents a viable option for individuals looking to secure their essential properties while navigating financial difficulties. If you are considering bankruptcy, it is vital to explore keep and pay as a potential solution while consulting with a qualified bankruptcy attorney to ensure compliance with state regulations and to maximize the benefits of this exemption. Understanding your options is crucial in achieving a fresh start free from overwhelming debt.